We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
My name for the record is, I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendants, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Okay. Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to.
Welcome back to the channel. Today's case is a textbook example of how courtroom confidence can clash with legal reality. We're watching J.P. Morgan Chase Bank versus Marcus Campbell, a sovereign citizen who's convinced he can outsmart both the judge and the system. On the surface, it's just a pre-trial hearing. But underneath, it's a slow-motion unraveling of the pseudo-legal tactics that never seem to hold up under real law. What's fascinating here is the mix of confidence, confusion, and contradiction. Marcus insists he's not really Marcus Campbell, but rather a beneficiary of the name, a classic sovereign argument meant to dodge jurisdiction.
Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22. And then we subsequently filed our motion for summary disposition on 12 responses, as it were filed, the last of which is response to plaintiff's counter defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then he in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79.
Here we see a familiar moment. The sovereign citizen demands proof of claim or evidence of lawful authority. It sounds dramatic, like they're exposing a hidden flaw in the system, but in practice, it's meaningless. Courts operate on established law, not on the pseudo-contract theories floating around online. This kind of phrasing is borrowed from Freeman on the Land scripts, boilerplate documents promising a legal loophole that doesn't exist. Every time this argument appears, judges have to pause and politely wade through pages of jargon, only to find there is no coherent claim underneath.
I disagree, and I'll stand on my brief.
And you stand on your pleadings. Okay.
Which was
All right, the court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there's no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit.
This section captures the heart of the problem. The judge's patience here is notable, but the reality is clear. Marcus has inherited a legal strategy that no one in the chain truly understands. Each link in that chain, from online gurus to followers, repeats the same empty rhetoric, hoping it sounds official. Courts run on evidence, jurisdiction, and procedural compliance. Without those, even the most confident litigant ends up stuck in a loop of circular reasoning. What makes it tragic, though, is that many sovereign citizens genuinely believe they're uncovering hidden truths, when in fact, they're walking straight into legal defeat.
Calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer. Is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr.
Yes.
Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
It's hard to believe this single case has stretched on since May 2022. If sovereign citizens are skilled at anything, it's delay, filing motion after motion, repeating phrases like special appearance, and questioning every step of the process, all designed to stall proceedings. The courts can't be outweighted. Whether it takes months or years, the facts and law eventually win out. What we're watching here is a slow erosion of a strategy built entirely on deflection. And when that final ruling hits, all the procedural games disappear in an instant.
So then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22-198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearances?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with a genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the
No.
court has had the opportunity to read your brief. And I thought it was an interesting set of.
This moment is incredible. After insisting for months that he never entered into any valid contract, Marcus ends up admitting the debt himself. That's the breaking point for nearly every sovereign citizen argument. Once you're under oath or on record, the contradictions become undeniable. They claim no contract. But the paper trail, the payments, and the account activity all prove otherwise. Judges don't need emotional outbursts or dramatic speeches. They simply apply the rules. And in this case, those rules lead straight to one conclusion. The defendant's own words sealed his law.
Prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all
filed here, and I see
Yes, sir.
all.
That's all I know.
I know, for example, that you cite federal rules of civil procedure. I
Right.
know, for example, that you cite 28 USC 2403. I
Mhm.
further note you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor. There is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today.
Right after losing to J.P. Morgan Chase, he walks straight into another battle, this time against Portfolio Recovery Associates, in a pattern we've seen repeatedly. The more often these defendants lose, the more they double down on the same discredited logic. The next hearing plays out almost identically, giving us a front row seat to deja vu in a courtroom, so buckle up. Because if you thought the first loss was rough, the second one takes the same mistakes and amplifies them.
This is case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. Okay, I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right. Anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record.
Here's where things get technical and painfully ironic. Marcus files what he calls a brief and memorandum of law, likely believing it carries the same authority as a lawyer's motion. But as any attorney knows, these filings require structure, citations to statutes, case law, and a logical argument tied to the facts. His version, however, is a patchwork of copied text, federal citations that don't apply to state court, and vague philosophical points about contracts. The judge handles it graciously, acknowledging the filing, entering it into record, and then moves directly to
what I received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is, to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13, 23. In this matter, Marcus Campbell or anyone representing Mr. Campbell, if you're on the Zoom, please say something at this time. The matter is set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition? Update me on any information that you may have at this time.
No, Your Honor, no response to the motion and no contact from defendant.
It's failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicate history of this these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted.
And with that, The judge delivers yet another decisive ruling. The motion for summary disposition is granted, marking Marcus Campbell's second loss in a row, and another firm rejection of sovereign citizen tactics. What stands out here isn't just a loss itself, but the calm professionalism of the court. Every argument, no matter how elaborate, was met with patience, logic, and law. These cases show exactly why real-world legal systems can't be gamed by internet theories or magic words.